I'm a pass out of 2011. I've been extensively practicing in the Delhi courts, and my forte and my specialization in so many years of practice has been in the field of banking. I have extensively practiced in the courts of DRT, DRAT, High Court, and Supreme Court concerning the banking regime. And over the period of years, I've developed a skill set wherein I was inducted in the panels of Bank of India and SBI. And now I'm associated with Khurana and Khurana. Khurana and Khurana is a tier 2 law firm with a massive team in the IP department. And now they're expanding in the vertical of banking. And we'd like to make the public as much as aware as we can in the banking regime. So the purpose of this webinar is to reach out to every person who has ever been involved in a bank transaction and has ended up facing the wrath of the bank, sometimes I may have to call it. And sometimes the bank has been on the other side. So this is a webinar for the banks and for the borrowers and everybody who's ever transacted with a bank. So this seminar, I'm going to specifically deal with two laws, one of which is Sarfeasi and the other is RDDB and FI Act. These two are specialized laws, and they are concerned with the recovery of debt owed to a bank. So to begin with, I will slowly and eventually come to my website. So the webinar will follow the regime where I will try and talk about the banking laws in general. Then we'll specifically get down to the acts to be discussed in this webinar as you. And to begin with, basically, what is banking law? At one given point of time, India has a very rich trade of business. And at one given ancient medieval time, there were sahukars, there were seths who would lend out money. They were called the money lenders. But as time evolved, people could not rely and function on the money lenders. So there was a need felt during the British India that there should be a banking regime. So the most earliest of laws, you can see the imperial banks during the British times when the presidency towns used to have these banks, and they used to lend money to the public. Then the banks were nationalized after independence, and the first act that was passed was the Banking Regulation Act. And the RBI was given the status of the Bankers Bank under the RBI's Act of 1949, wherein RBI was acknowledged and established as India's central and most premier bank. A banker's bank is what the RBI status had eventually come to. And slowly and eventually, I'm going to talk about the whole vertical of banking sector and then come down to the two acts that I have intended for this webinar specifically. So without much ado, let me begin with my small session. So as a layman, what all do we need to understand about banking laws? One and foremost, RBI is India's banking sector, which is the most premier bank. And you have to understand that all the countries in this world have banks. And the financial conditions and the economy of different countries are functioning at a different rate. And I must assure you that India at the moment is far better than other countries, be it credit, be it market risk, be it liquidity and surveys. They all seem to suggest that Indian banks have withstood the downturn that America probably faced. And India is now said to be one of the fastest growing economies in the world. In America, there was a down time when bankers like Goldman Sachs and the Lehman Brothers went bankrupt. In fact, it came to a stage where they had to file for insolvency. What happened practically was they were giving out loans and loans against mortgage, and none of it was recoverable. The laws weren't stringent enough. The people were smart. The people were taking the bank's money and running away. There was no mode for recovery, and eventually there was an insolvency filed by the world's most strongest bankers in America. Touch wood, India has not seen that. But what India has seen is a boom. This sector has turned from a caterpillar to a butterfly in the decades. They have performed functions of lending money to traders and craftsmen, and it has flourished in recovering. And how is it recovered? Because India has transformed its recovery laws from time to time. In the ancient times, as I said, there were Mahajans, Seths, Sahukars who used to give their money to tradesmen and crafters. But in the modern day century, there are general banks in India, and many banks have come into existence after the presidency towns that started with the quasi central banks for quite a while. And then it was merged into something called the Imperial Bank of India, where after the Swadesi movement, there was a need felt for establishing a bank of Indians. So one of the oldest banks could be your Bank of Baroda, your Central Bank of India, Canada Bank. All these PSUs are one of the oldest banks. And a landmark evolution was happened in 1934 when a decision to set up the Reserve Bank of India was taken. And Reserve Bank started functioning way back in 1935. It has since been called the Bankers Bank. It derives its powers from the RBI Act of 1934. So, along with the nationalization of a lot of banks, there were two major events in the modern banking system that happened. And all these banking and acquisition companies got together, and 90% of all banking business in India came to be controlled by the government. Post the liberalization, the policies of the governments changed, and a lot of private players entered into India. But those private players were always watched and strictly regulated by the parent bank, that is the RBI Bank. Further, there were regular checks in the compliances of various guidelines and irregularities of those private players so that tomorrow the public's money is not misappropriated. So, what is a bank? Bank, and what is the purpose of a bank? Bank is nothing but somebody who keeps the money of the people. For you and me, bank would be some place where we deposit our funds, where we deposit our life savings, and we expect them to be protected in the most efficient manner. Bank gives you a rate of interest for your savings account, for your FD, for your everything. So you entrust the banks with your money and hope that eventually keeping it in the banks will give you a return much higher than what you deposited. So how is that happening in India? It is happening because there are stringent laws in place, and RBI, as the central bank of the country, has operated all private shareholders in the bank. It replaced all the older banks and issued new currencies, made new better policies. And after nationalization, it took three most important roles. So what the most three? It was a regulator of banks, first and foremost. By regulator of banks, I mean that every bank that is there as a PSU functioning in India. So they are only allowed to function as per certain guidelines. They cannot function under the whims and fancies of their own accord. So they have to follow a regulatory framework. Where does the regulatory framework flow from? The regulatory framework flows from the RBI, and that's how they are governed. So giving you a very minuscule example is that the banks are not allowed to charge an exorbitant rate of interest on a defaulting account. So they cannot charge anything and everything they like. So there is a particular policy in the RBI portal that says here is the cap on such an account that can be charged on a money lending. And that's where the cap stops for all PSUs. In the modern times, there are a lot of private players that are violating these regulations, but as a customer and in public equity, justice is being given to people who are being mishandled by these banks. But to a large extent, you can rely on a public sector bank that it is well controlled by the RBI, and the government is also taking money from the RBI. So the bankers bank has formulated such good legislative framework for all of the banking sectors that you can be secure while keeping your money in the bank. So say that day won't come like it came in America, where you went to withdraw money and there was no money in the bank. That sort of a day you will not see. So let me talk about the key legislative frameworks of the banking sector. Indeed, there are a lot. But in today's webinar, we are going to discuss two main. One of them is Sarfeasi and one of them is RDDB FI. Why were these laws formulated? These laws, it is important that we understand why these laws were formulated. And yes, if you have any questions, you may write to me on the comment section below, and I will try and revert as many as possible by the end of this webinar, and hope that everybody who's ever dealt with a bank has a solution after watching this webinar, or if not a solution, at least an idea of what he needs to do as his next step. So in today's webinar, we're going to talk about Sarfeasi and RDDB FI. These are two laws. I will come on to them specifically once I share with you my slides as to what are the full form, what are the sections, what is the definition, what is the purpose, what is the objective, what is the intent, legislative intent, and the procedure, of course. But giving you a skeleton of what these laws mean. So starting with RDDB FI 1993. Now 1993, there were a lot of debt on the Indian banks, and the banks were unable to recover money because uh, banks would give out money and the people would abscond. People in India are pretty good at that, I must say. So somebody who's borrowed money knew that the banks had to go to a civil court and then take action against them. And the courts in India are flooded with cases, flooded. So everybody was quite aware that they may be able to outrun a bank as far as recovery is concerned. But I must tell you, that is not the case anymore. Today, a bank can come to your house, ensure your house is taken over by them, you are outthrown of the possession, your bank accounts are sealed, you are going to the jail, and then the bank will also ensure that they sell off your property in order to recover their due. And how do they do this? They do this with the help of two very important legislative frameworks of the Indian era, of the Indian times, I must say, is RDTB FI, which was initially formulated for the recovery of debts due to banks, as the name suggests, and financial institutions. So RDDB FI stands for Recovery of Banks and institutions. This was basically formulated because the government felt that they need to find a smarter way to recover money of the banks, and one of the ways could be making a special tribunal for them. By establishing this tribunal in 38 parts of the country and having 5 appellate tribunals, you could say it was a fairly successive, yet it has its flaws, but a fairly successive legislative framework wherein a bank would go, file an OA. OA is an original application, you could just call it a plaint, and in those plaints try and depict, to the Bankers Book Evidence Act, in compliance with the Bankers Book Evidence Act, as far as how much money has been lent to a person named XYZ. A person could be a company, an individual, but anybody with an amount of 10 lakhs and above. They would go to these tribunals once the amount and above, and in some cases 1 lakhs, provided the state government is given a notification. So this is a central act, and the banks would go try and avoid the hefty procedure involved in case of a normal civil suit, because in case of a normal civil suit there are a lot of steps that come into play. Out here there were not so many. On the filing of an OA, a simple written statement could be filed, and on appreciation of evidence, a final argument, and a mandate was given under this act that the case needs to be resolved within a period of 180 days. However, coming from a practical perspective and a practicing lawyer in this court, this time boundation has not really been abided, because now these courts have also been flooded with recovery tribunals. These recovery tribunals have been flooded with cases, and there has been successful recoveries. However, most of it has again gone as an unsuccessful legislative framework. So what there was a need felt in 2002 that this law is sort of fading out. It is redundant. So we need to strengthen the back of this law. So what they did, they passed the Sarfeasi Act. Now Sarfeasi is what? Sarfeasi Act 2002 is a legislation whereby the banks, without having the need to go to a court, could take action on the properties mortgaged of the borrowers. Yes, indeed, they need not take permission from anybody. How could they do this? Once, say you have borrowed 10 lakhs and above rupees, just giving you a simple example, we'll come on to the cases later, by simply issuing you a notice that was mandated under the Sarfeasi Act, they would, let me just explain to you when was that notice to be issued. So say you have an account in a bank, and you have taken a loan for which you're supposed to pay a monthly EMI. That is how the regime works. I'm sure everybody attending this webinar will be quite familiar of that fact. So on the 90th day, when you're unable to pay the debt that you owe to the bank, so the bank will issue you a notice. It is called the 13-2 notice. It is a notice wherein the banks will briefly explain to you that your account has been classified as a non-performing asset. Once your account has been classified as a non-performing asset, they expect you to make a payment within a period of 60 days on the issuance of that notice. Failing which, the bank will take steps under the Sarfeasi. Those steps may vary. Those steps would be take over the possession of your property, get you arrested, attach your bank accounts, anything and everything that can help them recover their money. And they could also approach the district magistrate or the CMM, that is the chief metropolitan magistrate of that district where the cause of action has arisen or where the property is situated, and with the help of that authority, they would come down to your house, evict you out of the house, and take possession of it, just like a process that you often see in movies with the goons doing it, but this time it's the banks doing it. And where do they get this power from? They get this power from the central government to come and seal your property at once. They get this power from RBI that has given the public sector banks a vast constitution of powers and functions to do this. And most of it flows from RDDB, FI, and Sarfeasi. So you understand today, if you're a borrower of the bank and you're not willing to pay the money back, you may quite as well be aware that they will come after your property. And every regulation that is framed these days generally keeps a collateral. So your collateral is sure to be taken. So what you can do to avoid that, is to see that once you understand the laws that I'm about to explain to you, and you see that the bank has not complied at any given point of time to the mandates given either by the RBI or by the acts regulating the banking sector, such as the Banking Regulation Act of 1949. Now, Banking Regulation Act of 1949, it deals with the banking business on how the banks are supposed to handle the banks business of the banking. They are supposed to take certain precautions. They are supposed to carry out certain steps. And in case those steps are not complied, then the banks have not done their job properly. And as a borrower, you could point that mistake out that the banks have indeed not followed the regime as mandated for them, and that you are not the person at fault. And you could take the bank at task. But largely, the banks have always had a team and a compodium of members of high education, so their documents are quite intact. So, coming from a practical perspective, it is really hard to win against the bank, but you can always show that there has been an error in calculation. So, let's moving on from here. I just explained to you what the powers of these banks are today. So, one of the ways, giving you a situation again, before coming on to my slide, which specifically deals with laws, and thereafter it will be strictly business as far as this webinar is concerned. So I'm trying to make it more interactive in whichever way I can. Um, the laws have been passed for banks also. Like the laws have been passed for people borrowing the money from banks, laws have been passed for the banks to comply also. One of which is Prevention of Money Laundering Act 2002. Then there have been certain lok ayukt set up and lok adalat set up all across the nation, wherein the banks really need not go to the court, and what instead they could do is call you to the process, and then under those process of fair equity and good conscience, because some or the other given point of time a borrower, for whatever purpose he's borrowed the loan. So, say, taking my example, I've taken a home loan, and tomorrow I do not feel like doing a job, and I don't know where the money is going to come for the next 3 months, and I'm defaulted my payment. So, I could approach to these one of these lok adalats and get it restructured. But you have to show a bona fide, and you also have to be prepared that you have to give them some money for them in order to not proceed against you. Now, these two legislations that I'm going to talk about, let's directly get on to it and try and understand what is the objective of these securitization acts and these debt recovery acts at large. So currently in India, there are around about 38 debt recovery tribunals existing. And in Delhi, I'm a practitioner in Delhi. In Delhi, there are three. They're divided into north, south, east, and west. And there's a DRAT. DRAT is the Debt Recovery Appellate Tribunal. The two laws that I've been talking about, the RDDB FI and the Sarfeasi, are both applicable before these courts, and the subsequent rules are also applicable before these courts. So these days, it is a very lucrative career for lawyers to actually specialize in the banking fields, because now and then banks come out with panels, and you can always approach companies who've been under debt and are unable to pay it on some virtue or the other, some ground or the other. You could help them out. Who is a borrower? What is a borrower does? And all these questions I will now answer. Now let's have a look at my slide.